It is my pleasure and honor to welcome to our stage the Honorable Leondra Kruger, the Associate Justice of the California Supreme Court. While she comes up and we kind of get settled, I wanted to share, here I'll sit. Justice Kruger served in the United States Department of Justice as a Deputy Assistant Attorney General of the Office of Legal Counsel. Many of you know that from 2007 to 2013, she served in the department as Assistant to the Solicitor General and as Acting Deputy Solicitor General. During her tenure in the office, she argued 12 cases before our United States Supreme Court. In 2013 and in 2014, she received the Attorney General's Award for Exceptional Service, which is the department's highest award for employee performance. She's also been in private practice and has taught as assistant professor at the University of Chicago. Here's where I think it really gets fun. She joined our court in 2015, coming back from DC to California. Up until a few days ago, she was Governor Brown's most recent appointee. I love that I don't have to say firsts right now. She is the 7th female to serve on the California Supreme Court. She is the 4th African American to serve on the California Supreme Court. And she's the 2nd African American female. I love there are no number ones in front of that we've already taken them off the table. But she took one off. She was the first justice to give birth while in service in the office. To that one as well. We're going to have a fun conversation. Well, I won't call this fun conversation, and recognizing that not everyone here today practices in front of the California Supreme Court. You might not even practice on a regular basis in front of the Court of Appeal. And we really wanted to take some time and have a conversation that really applies to all lawyers in California where they are today. Try to make it really relevant. So we're going to start with this one. Judicial independence. And Justice Kruger, when you think about judicial independence, what does judicial independence mean to you, and how do you see that play out in the role of the California Supreme Court?
Sure. Well, first of all, I just want to say what a pleasure it is to be here this morning, and thank all of you for coming out into what I know are very difficult conditions. I know all of our hearts go out to the folks who are suffering through this tragedy up north. Judicial independence is an essential component of the way that our system of government is framed. You know, and when I think of judicial independence, I think of it not so much in my capacity as a judge, because of course I think I should be independent. But in my capacity as a citizen, our courts exist to protect the rights of citizens, to protect the foundational values that are embodied in our Constitution. And courts can't do that job, can't play their role in the system of separated powers we have in our democracy unless they are able to do that without fear of reprisal or control, either from very powerful people or from majorities who may not be as concerned about protecting the rights of the unpopular. This comes up for us as judges on a daily basis. We are regularly called on to decide cases about very unpopular litigants, people who in some cases have committed terrible crimes. We're regularly called on to answer questions about the constitutionality of laws that have been enacted by the people's elected representatives, or in California that have been enacted by the people themselves directly through the ballot process. And in order to do that job, in order to perform the role that we're called to perform in our system of government, we have to be able to do that without being afraid. Ultimately, judicial independence is really a question of being able to perform that job of impartial judging without fear.
And so with that, since that's so crucial to the rule of law, to kind of the realization of the rights and protections that we have in our Constitution, both state and federal, what role can we as lawyers play in protecting and defending so that that judicial independence remains?
I think that lawyers have a really critical function to play in terms of educating the public about the importance of our institutions, educating the public about what it is that courts do and how it's different from what the other branches of government do. I think so often public perception of what courts do is shaped by newspaper headlines, which tend to report the bottom line of court decisions as though courts were deciding whether a particular law was a good idea, or as though they were deciding whether they liked one litigant versus another, which is not at all, as you know, as everybody in this room knows, it's not at all how we approach the job. The job isn't a question of what we think is good policy. It's not a question of what law we would write, if we could write the law. It's not a question of who we like or who we dislike. It's a question of how we can impartially decide the cases before us under the law as it exists and perform that role that we are assigned to perform in our democratic process. And I think the more lawyers can sort of stand up for the importance of that distinctive role of having courts that are impartial, that are outside of the political process, the more that lawyers can educate our communities about the distinctive role of the courts, I think the more solid foundation we will have for upholding the law going forward.
Now to move us to the Court of Appeal and the California Supreme Court specifically. In a lot of ways, sometimes people aren't, especially the general public, not as familiar that in California, the Court of Appeal is a court of error correction and comes in with a standard of review, but that when we move up to the California Supreme Court with discretionary review, that this is a more policy-setting court set with the boundaries of the California Constitution, where we are. And so because it's a hard jump to the California Court from the Court of Appeal, would you like to do microphone? And so to help with the audience to kind of know, to get to the California Supreme Court, if you were looking at the 2017 statistics for civil petitions for review, only 6% were granted. In math, that's 807 of the 860 were denied. All right. On criminal, 2% are granted, so they get into the door on the policy review. That means 2,292 of the 2,244 were denied. Which begs the question, what makes a good case to get up to the California Supreme Court? And as a practical matter, thinking, what does that petition for review look like? It's going to get in the door.
So the two criteria that we apply in deciding whether or not to grant review in a case, as Wendy says, they do not include whether we think there was error in the decision below, because we don't have the bandwidth to correct every case of possible error that we see. The reason our court exists is really to address a more system-wide set of concerns about the integrity, the uniformity of the law as it exists across the state of California. So we're looking primarily for two things. One is whether there's confusion about what law ought to apply in a particular kind of case. The classic example is a case where there is a conflict between two different Court of Appeal decisions. And in those cases, there is a very strong imperative for the California Supreme Court to intervene, because unless and until we settle the disagreement between the Courts of Appeal, there will be no concrete guidance across the state of California for litigants and trial courts to follow in order to figure out how to resolve that class of cases. The second big category of cases are cases of first impression that are of statewide importance. And there is where we often have the most robust discussions around the table to determine whether or not the court should grant review. So in cases where there hasn't been a conflict yet, but the case is of sufficient importance and raises sufficiently unsettled legal questions that there can be a case made for the California Supreme Court to jump in to clarify the law across the state of California at a comparatively early stage. When we're looking for petitions for review, we're looking for petitions that sort of clearly present one of those two types of scenarios and make the case not just for the existence of some error in how the case has been handled so far, but makes the case for why the case presents a legal issue that needs to be resolved at the highest level of our state court system in order to settle confusion, in order to provide adequate guidance to trial courts and litigants across the state.
In thinking of that framework, are there cases that you hoped the court would have granted review and they didn't? Or, and you might not be able to tell us why. But in that thinking of, on the flip side, of why you might decide to vote against taking a case at a particular time.
There certainly are cases where I had hoped the court would grant review and I was outvoted. Some of that is public information. You can see each week on our order lists there are cases where some of us will have been noted as having voted to grant, and you can tell that we were on the losing side of that discussion at conference. But I really spend much more time worrying about the cases that we do decide to take and making sure that they are the appropriate vehicles for deciding these issues, recognizing again that when we take a case, we're not just deciding a particular dispute between two particular parties, we're deciding an issue that is going to set precedent across the entire state of California. And so we want to do that in a case where there is an appropriate record developed to allow us to explore all the issues that need to be explored. We want to do that in a case where arguments have been preserved and fully fleshed out in the lower courts so that we won't discover when we take the case up that we can't answer the question that needs to be answered across the state of California because of some quirk in the litigation history of the case. So we have to do a certain amount of due diligence before we decide that we're going to grant review in a case for the purpose of promoting the development and uniformity of the law.
So if we've won the lottery and we've gotten into the 6%, and we're now coming up into the merit stage, from a briefing standpoint, what do you find the most helpful or least helpful in the merits arguments as they're presented to you?
I'll start off with what I find the least helpful.
Please help. That might be very helpful.
So I guess I've always thought of the most effective appellate briefs as being a little bit like what you would think of as draft appellate opinions. And that sort of means a few things to me. One, that means something about the tone. I find the most effective briefs are ones that sort of try to adopt a certain amount of sort of reasonableness and candor and sort of even keeledness of the sort that you would hope to see in an appellate opinion once it came out. And what that means concretely is that, sort of no ad hominem attacks against opposing counsel, no sort of overstatements of what the law will support. By definition, if a case has gotten to the California Supreme Court, it's a hard case. It means that there are reasonable arguments on both sides. And so it doesn't sort of serve a great deal of purpose to try to belittle the other side or to try to ignore obvious counter-arguments because we will be looking at those counter-arguments and we will recognize that they have some potential merit. So it's much more helpful to give us the tools for thinking fully through why those counter-arguments may not ultimately carry the day rather than simply sort of trying to shunt them to the side. Most of the cases that we decide these days are not common law cases. That is a part of our docket, but these days most of the cases we decide are governed by statutes. or by the text of constitutional provisions. And so having a sort of close focus on the actual text that we are being called on to interpret is really crucially important. And, again, I think candor is, above all else, the most important element of an effective brief. Ultimately, we are going to spend a lot of time working with those briefs, looking at the precedent that exists, looking at the arguments, looking closely through the record, and sort of the more candor that advocates can bring to dealing with all of those very important materials, the more helpful that brief ultimately will be, and the more effect it will ultimately have in the deliberative process.
And since it's such a small percentage we're getting in, the place that I think a lot of attorneys will find themselves if they're participating in the California Supreme Court conversation is advising clients and representing clients in the amicus component. And so, which begs this question of how valuable do you find amicus representation and the briefing that comes to you that's supporting the merits briefing?
I am a big fan of amicus briefs, and it's primarily for this reason. Again, when we're looking at cases, we're trying to get a sense of what the law should be throughout the state of California, looking beyond the four corners of the case before us. And amici can often play a really critical role in helping provide that broader perspective, providing that background of sort of here is how this issue often comes up in other cases, and here are some of the concerns that you ought to be thinking about as you're crafting a rule of decision. The most, I think, effective amicus briefs are the ones that bring that sort of institutional perspective, that bring that broader perspective to the issues that we're considering in a particular case. The least effective amicus briefs are the ones that are essentially just sort of rehash the legal arguments that are in the parties' briefs. But amicus briefs can be very effective in providing that sort of broader perspective, and in some cases, sort of filling out some of the legal analysis that may not be as fully fleshed out in the party briefs.
So shifting from the kinds of cases, I would like to shift a little bit more to your approach when you now have the cases in front of you. So how do you approach and we're kind of thinking of individually, your role in the policy setting role as a justice, as you're evaluating and kind of figuring out where you fall in the decision-making point on the case?
The first and most important part of it is doing my homework. So the first thing I will do is I will read every case that has been written on a particular issue. I will read the parties' briefs very closely, and I will sort of try to develop a set of questions that I have about the case as I go through, and we'll have to save those for oral argument, which is the time that I generally like to spend kind of kicking the tires on my theories about how to resolve the case. I think that sort of in the role that we're in, sort of the most important component of what we do in a lot of ways is doing that deep digging, trying to figure out how we got to this place. Why did the law develop in the way that it developed over time, and what can we learn from that development about the underlying principles that help us resolve these new cases that raise difficult and unsettled questions. I spend as much time trying to learn from the lawyers in the case, and very much value the lawyers' role as educators, really. Sort of nobody is going to know the case better than the lawyers who've been handling it. And so in oral argument, that is the time when all of us sort of try to extract as much additional information as we can from the lawyers about what they know about the specifics of the case, what they've been thinking about in terms of crafting arguments, what their experience may have been as practitioners in a particular area of law. And then the job is really to go back and try to assimilate all of that information to craft an appropriate rule of decision that not only resolves the case before us appropriately based on the facts and the law of that case, but that also performs its role in the development of the law across the state of California, that continues a dialogue between our court and the other courts in the system, as well as in some cases a dialogue between the courts and the legislative branch, which may be prompted to act by having additional information about where there are gaps in the law or significant policy choices that need to be made.
So you've done your homework. So then the question is, and to the extent that you can, kind of let us peek behind the curtain, so to speak, and when, from a procedural standpoint, do you talk to your colleagues before argument? Is it all by yourself? Is it talking after? Is there like a kind of natural arc that happens every time, or are people doing it in a different way?
So, as soon as we grant review in a case, the Chief Justice will assign one member of the court to sort of shepherd that case through the process. That person becomes the presumptive author of the court's opinion, although whether things ultimately work out that way usually remains to be seen. And that person will produce what is kind of a memo to the court, laying out the issues in the case and presenting that person's best take on how the court's opinion ultimately ought to read and how the issues ought to be resolved. And all of the other justices, upon receiving that memo, will respond to it in writing. And there's often very robust back and forth and sort of informal hashing out of some of the issues that goes on through that process. And once all of the other justices have weighed in, then at that point the case will be calibrated for oral argument. And after oral argument is the time when we all come together to sit around in person around a table and actually discuss the cases in person and cast our final vote on the case, at which point the clock starts running for producing the court's opinion, which has to be issued within 90 days. So that's the essential process. There's a significant deliberative process that goes on before oral arguments, largely conducted in writing. And then we have in-person conversations and an actual casting vote that occurs after oral argument, once we've had a chance to hash things out with the lawyers. And then the conversation will continue as the opinion drafting process goes on, and there's often very robust back and forth as justices exchange suggestions, concerns about the way opinions are written, about how particular sentences, even down to the choice of a couple of words, might be read in future cases, and what sort of impact that will have on the context of litigation going forward.
Well, I'm thinking that all of those things are being taken into consideration, especially when all of the justices are now coming onto that decision point. You're really getting down to the specificity of words. I'm going to assume we're all serial comma people, just
Obviously.
practice. See, that's an appellate lawyer funny. I realize you might not have gotten that one. Which brings me to, you have, sitting on our bench, and even as our bench is now going to kind of fully become constituted now, which is a wonderful, for those who've been paying attention that we've been missing a full-time justice on the California Supreme Court, and now what it will mean for that body to be fully in place, and the change of the work. If as you've been paying attention, our bench now has a former people in totally different backgrounds. They're coming from all different vantage points of prior practice and whether they did practice or when they've been practicing, and bringing this diversity of legal background thinking to it. I'd just like to come back to you on that because you were a practicing appellate lawyer for quite a long time in that role, how has that influenced your thinking now as a justice on the other side, as you're doing this evaluation and then writing in the
I think in ways my background as an appellate lawyer made this transition feel very comfortable. I think as an appellate lawyer, you sort of get in the habit of trying to put yourself into the judge's shoes as you're thinking about how to craft arguments. You think about, well, what kinds of arguments would I find persuasive? And if I had to decide this case, how would I be likely to think about these issues? And so The habits that you form as an appellate lawyer, I think, translate in a lot of ways to the work of appellate judging, of actually deciding cases. The big difference, of course, is that, there are certainly some cases where I thought, boy, I'm sure glad that I don't have to decide this. This is really hard. And I no longer have that luxury. I would say that the other big difference is, I spent a big chunk of my career in government service at the United States Department of Justice, which is essentially the largest law firm in the country. And one of the great luxuries of working there is that somewhere in the phone directory, somewhere in the country, I could always pick up the phone and find the person who was the nation's expert on you name it. So if I had a case about forensic drug testing, I could call up the head of the Drug Enforcement Administration's labs and talk to him about how exactly forensic scientists do their jobs. If I needed to find out about the conduct of child abuse investigations in the Indian country, I could call up the experts around the country and find out what their experiences had been. And I got to sort of assimilate all of that information and bring it to bear in the arguments that I was making before the court. I can't do that these days. I can't just pick up the phone and call somebody to find try to figure out how something works. And so I, like all of my colleagues, we are really dependent on the lawyers to sort of do that homework for us and to bring to bear all of the information that is sort of both necessary and helpful to us in having a full understanding of the issues before us. Much as I sometimes wish that I could go out and collect the information myself, the nature of our process is we really depend on the lawyers to sort of do that educating for us.
Do you miss the advocacy role?
I really enjoyed it, and it was such a privilege to get to do some of the things that I did in practice. It was a real privilege to get to argue on behalf of the United States and the United States Supreme Court. But I really feel incredibly fortunate to get to do what I'm doing now. And I've learned that I always had a sense as an advocate that things must be much easier on the other side of the bench. It turns out that's right. It's a much less stressful job to be asking the questions than answering them. But it's, to get to go to work every day and get to do the kind of work I've always loved doing, and to get to do it in a capacity where I get to be of service to the 40 million people of my home state is really it's such a remarkable privilege and honor.
To let you go down memory lane just a bit, do you have a memorable oral argument or argument experience from when you were back in that advocacy role, like a favorite one, or maybe you remember it because it wasn't the most favorite one?
I have all of those.
All of those.
I think probably my most memorable arguments in some ways was probably my first, in part because by the time I argued my first case in the Supreme Court, I had sat in that courtroom quite a bit, and so I had seen a lot of oral argument. The U.S. Supreme Court bench is now, as it was then, very hot. So, there are at least 8 justices actively asking questions. You're often lucky you can get more than a few sentences out in response. And I had seen some people deal very well with that situation, and I had seen some arguments go not so well, and I really didn't want to be in that category. So I decided to channel my nervous energy into preparing and over-preparing some more for that argument. And by the time the actual argument rolled around, I had spent so much time worrying about it that I was really too tired to be nervous anymore. And when I stood at the lectern, I remember realizing for the very first time just how close it is to the bench. You don't realize it's sitting anywhere else in the courtroom, but you can only see one or two justices at a time that are standing there, and it really contributes to a sense of just having a conversation with the judges, which is exactly what you hope oral argument will be. And so once the questions start going, you're turning to a person who is a very thoughtful, very important judge, but who is ultimately seeking your help in answering very difficult questions that come before that court. And I just remember having a real sense of just what a privilege it was to get to be part of that conversation and get to provide that help as best I could.
You now, in your role, are often credited with asking the advocates typically the most difficult question they receive during oral argument. And as I read those responses, many times it's that you really ask a question that gets to kind of exactly where everybody's wrestling. You don't get to go over on the easy stuff anymore. We're going to the harder question. What would be your advice when people are arguing before you in that, to make the best use of their time, not just for your vote, but for the bench as a whole?
So I would say two things. One is having a very clear sense of what exactly you want from us, which is a sort of easy thing to say. It's a harder thing to do because, of course, every lawyer stands up at the lectern, and what you want from us is to win, right? You want your client to prevail, but it's important to recognize that we're a little bit less concerned with that and a little bit more concerned with how we're going to do our jobs, which is to write an opinion that explains why your client should win, if your client should win, and more importantly, what the scope and the contours of the rule of decision ought to be in order to provide clarity to the law going forward for other people who are encountering somewhat similar but maybe slightly different back patterns. And so having some sense of what it is you'd like to see in the opinion, what do you suggest we say when we're resolving the case, and then we can spend time talking about the merits, the advantages and the disadvantages of that approach. But it provides a sort of concrete way for us to sort of get into the meat of our decisional process. I think that the other thing I would say is that in every case, because these are hard cases, because there are going to be good arguments on both sides, there are almost inevitably a set of questions that you can, finish reading the briefs and you can imagine that any sort of, reasonably disinterested person is going to have about the case, about your position. Usually, it's about 5 questions that you can anticipate that are just tough for you. And having an answer prepared for those sort of kind of reasonably anticipatable questions is a sort of an important part of the process. Recognizing that they're not necessarily going to be questions that are helpful to your side, but even so, having an answer prepared will at least alleviate some concern that some judges on the panel might have about what it would mean to rule in your favor. Recognizing that, again, that there's never going to be, sort of none of these cases are going to have all of the good arguments lined up on one side. There are going to be tough questions for both sides. And so ultimately it's really just sort of a question of figuring out what the best responses are to some of those weak spots in both sides' presentations.
I'm going to kind of bring us now into kind of a closing question. You're relatively a few years into this role of service and having had a full career in public service in another capacity, and looking down the years ahead of you, what kind of reputation do you hope to leave through this time of service?
I think that I don't spend a lot of time thinking about what kind of mark I want to leave on the law, and that's simply because we are a reactive institution. We don't set our own agenda. We answer questions that come up in cases that the parties choose to bring, and we answer them because there is a need to do so. in order to settle the law across the state of California. And so really I go into every case trying to handle it on its own merits, trying to think as carefully and as closely as I can, both about what the facts of the case suggest, about what the law that has been decided up to this point, what the law as written by the legislature or by the people themselves in the initiative process, what it means, and just try to get every case right on its merits. I think a really important part of the way that I think about the job is also in terms of how we explain our decisions. We're sort of unique among the branches of government in that we don't make decisions based on just a yes or no vote and then go on about our business. Every decision we make, we give our reasons for making those decisions and give them in writing. And through that writing, try to both explain for the help of the public, for the help of lawyers, for the help of judges throughout our system, what our thinking is, and through that process, hope to be part of a continuing conversation about the development of the law. And so I try to focus as much as I can on making sure that those reasons are explained in a way that's understandable and in a way that can perform those functions of being part of a continuing dialogue.
Well, thank you. We hope you're there for a very long time, doing just that. Thank you.